If you've been asked to provide your domicile address in regards to a trademark application with the USPTO, I want to explain why that is and what's happened. The USPTO a few years ago changed their rules and procedures to require a physical, or what they call domicile address, for every applicant. This was part of an effort to crack down on scammers. Whether or not it's worked is a different story. But every applicant must have a physical address tied to the file, and not just any physical address. So an office that is a virtual office space or shared office space, like a WeWork style office, because it's not a dedicated address specific to that business, the USPTO is generally not going to accept it. Same with PO boxes, same with mailboxes at other shared places like mailboxes, etc., or a UPS store. So if any of those apply to your application and the main address listed for your business, the USPTO requires a domicile address. This could be a home address of one of the owners or officers, or some other physical address. It also cannot generally be the registered agent's address, and cannot be a care of address, care of somebody else like a law firm. The good news is that the domicile address can be hidden from the public records if you have to provide it in that manner. So if you have a PO box or shared office space address and you're required to provide a domicile address, the domicile address, the secondary address, will be hidden from the public records so that it's not easily accessible for somebody reading the USPTO files online. That's the story with domicile addresses. If you have any additional questions about that, let us know. To hear more about the application requirements in general, stay tuned for the next video.